Welcome to the deep dive. Today we're tackling something that sounds dry but causes huge headaches in the real world. The battle of the forms. You know how it goes in business, right? You send a purchase order, they send back an acknowledgement, and the terms, well, they just don't line up. It's a mess. Under the old rules, that mismatch could kill the contract instantly. But today, we're diving deep into the Uniform Commercial Code's fix, Section 2207, which governs sales of goods. And we're going to use a classic case, Dorton v. Collins and Aikman, to figure out exactly when those extra terms slipped into an acceptance actually become part of your deal. Before we jump into the UCC fix, though, let's set the stage. How did the common law handle this? What happened when an acceptance had any term different from the offer?
Oh, the common law was notoriously strict. It followed the mirror image rule. Some call it the ribbon matching rule. Basically, if the acceptance wasn't a perfect, identical mirror image of the offer, down to the last comma, it wasn't an acceptance at all.
So no contract.
No contract. It was treated as a rejection of the original offer, and that faulty acceptance became a counteroffer. Commercially, this was, well, chaos, because people often performed anyway, right? They shipped the goods, accepted payment. Under common law, the terms of that resulting contract were usually the terms in the last form sent before performance began.
The last shot rule. Whoever sent the last piece of paper got their terms in.
Exactly. And the UCC drafters saw this as, frankly, rewarding sloppy paperwork and giving an unfair advantage. So UCC 2207 was written specifically to change that outcome, to reflect how business actually works. The idea is that if the parties act like they have a deal, they probably do have a deal, even if their forms are clashing. So our path today is clear. We need to break down 2207 into its three key subsections. First, how does 2207.1 decide if a contract is formed at all when forms differ? Second, if a contract is formed under 1, what does 2207.2 do with those extra or different terms? And third, what if the writings are just too contradictory? How does 2207.3 handle situations where the parties perform despite the paperwork disaster?
All right, let's start with subsection 1. You called it the Great Contract Savior. How does 22071 manage to find a contract where the common law found only a counteroffer?
Well, 22071 flips the common law presumption. It says that a response to an offer like an acknowledgement form that looks like an acceptance generally is an acceptance, even if it includes additional or different terms from the offer. So boom, contract formed. Right there. The added terms don't automatically kill it.
Okay, but there's always a catch, right? You mentioned an escape hatch.
There is. A very important one. It's called the proviso. The rule I just stated, that acceptance happens despite new terms, does not apply if the acceptance is expressly made conditional on assent to the additional or different terms.
Expressly made conditional on assent. That sounds like very specific legal language.
It is, and it's a high bar. The response has to make it crystal clear that the sender is unwilling to proceed unless the original offeror explicitly agrees to these new terms. Just saying subject to our terms usually isn't enough, as we'll see in Dorton.
Okay, so if you don't trigger that proviso, a contract is formed under 22071. But we still have those pesky extra terms floating around. What happens to them? Does the buyer suddenly have to agree to the seller's warranty disclaimer just because a contract was formed?
No, not automatically. That's where subsection 2 comes in. If a contract is formed under 12272, treats those additional terms as mere proposals for addition to the contract.
Just proposal.
Just proposals. Unless, and this is crucial, the contract is between merchants.
Ah, the merchant rule.
Right. If both parties are merchants, which is common in these scenarios, then those additional terms automatically become part of the contract unless one of three things is true.
Okay, what are the three exceptions?
1. The original offer expressly limited acceptance to its own terms. 2. The new terms materially alter the contract. Or 3. The other party has already objected to the terms or objects within a reasonable time after receiving them.
That second one, material alteration, feels like the big one. How do you know if a term materially alters the deal? Is there a clear line?
It's definitely the most litigated part. Generally, a material alteration is something that would result in surprise or hardship if incorporated without the other party's express awareness. Think major shifts in risk or remedies. An arbitration clause is the classic example because it changes how disputes are resolved. Big limitations on liability, disclaiming standard warranties like merchantability, shortening complaint deadlines, changing standard payment terms, those are usually considered material.
So things that significantly change the bargain they thought they were making.
Exactly. If it's a term that you'd really want to know about and agree to specifically, it's probably material.
Okay. Now, the last piece of the puzzle before the case, subsection 3, what happens if the writings are just a total train wreck? Maybe the acceptance was expressly conditional under the proviso, but the buyer never explicitly agreed. Yet the seller shipped the goods and the buyer accepted and paid. Is there a contract then?
Yes, absolutely. This is where 2073 steps in. It says that conduct by both parties, which recognizes the existence of a contract, is sufficient to establish one, even if the writings don't.
So acting like you have a contract creates one. Makes sense commercially.
It does, but the key is what terms are in that contract formed by conduct. And this is where it gets interesting. Under 22073, the terms of the contract are only those terms on which the parties' writings actually agree. Anything they disagreed on or any additional terms in only one form get knocked out.
Knocked out. Completely.
Completely knocked out. This is the knockout rule. You only keep the terms where the forms matched, plus any default terms provided by the UCC itself. Things of reasonable delivery times, implied warranties, that sort of thing.
Wow. So if your forms clash badly enough and you end up relying on conduct under 2 for its validity, you lose all your carefully drafted custom terms, your liability limits, your specific warranties, maybe even your choice of law.
Pretty much. You're left with a very basic contract based on agreed-upon core terms and UCC defaults. It's often a bad outcome if you were relying on your specific fine print to manage risk. It's the UCC's way of saying, you couldn't agree on the details, so we're ignoring the disputed ones.
That is a serious consequence. Okay, I think we have the framework now. 1 for formation, 2 for adding terms between merchants unless material, and 3 for contracts by conduct using the knockout rule. Let's apply this. Time for our deep dive into Dorton v. Collins and Aikman Corp. This case really tests that crucial proviso in 22071. Let's analyze Dorton v. Collins and Aikman. First, what are the legally dispositive facts?
Okay, the buyer was a company called the Carpet Mart. They placed something like 55 orders for carpets from the seller, Collins and Aikman, or C&A. These orders were mostly placed orally, often over the phone with a C&A salesman. After each oral order, C&A mailed a printed acknowledgement form back to the Carpet Mart. Crucially, the Carpet Mart always received this acknowledgement form before the actual carpet shipment arrived. And on the back of C&A's form, there was an arbitration clause.
An arbitration clause hidden on the back.
Right. And the Carpet Mart, well, they received these forms, then received the carpets, accepted delivery, and paid the invoices. They did this for all 55 orders without ever specifically objecting to the arbitration clause or any other terms on the form.
So consistent conduct suggesting acceptance of the goods.
Exactly. Then a dispute arose about the quality of some carpets, and the Carpet Mart sued C&A in court. C&A immediately moved to dismiss, pointing to the arbitration clause on their forms.
And what was the core legal issue?
The central issue was whether that arbitration provision on C&A's acknowledgement forms actually became a binding part of the contracts under Tennessee's version of UCC Section 2207.
Did C&A's form count as an acceptance that included arbitration, or was the arbitration term just a proposal that never got accepted?
Precisely. It boiled down to how 2207 operates.
What rule did the court apply to figure this out?
The court zeroed in on UCC 22071, specifically the proviso. The key question was whether C&A's acknowledgement form was expressly made conditional on assent to the additional or different terms, namely the arbitration clause.
So it all comes down to the exact wording on C&A's form.
Yes, that was the threshold question. Did C&A use the magic words to trigger the proviso?
What was the court's analysis? How did they dissect C&A's language?
Okay, so C&A's form had language that said something like, the acceptance of your order is subject to all of the terms and conditions on the face and reverse side hereof, including arbitration, all of which are accepted by buyer.
Subject to, including arbitration, accepted by buyer. Sounds like they thought they were making it conditional.
They probably did think that. But the Sixth Circuit Court disagreed. The court held that just saying acceptance is subject to certain terms is not the same as making it expressly conditional on the offeror's assent to those terms. The court wanted clearer language, something that really signaled, we will not make this deal unless you agree to our specific terms. C&A's subject to language didn't rise to that level. It was too ambiguous.
Wow. So that subtle difference in phrasing subject to versus expressly conditional on assent made all the difference. Did anything else in C&A's form hurt their argument?
Yes, significantly. The court pointed out that the rest of C&A's form actually contradicted the idea that acceptance was truly conditional on Carpet Mart's express assent. The form listed several ways the buyer could be deemed to have accepted the terms without explicitly saying, I agree. Things like just accepting the goods, or even just holding on to the acknowledgement form for 10 days without objecting.
Ah, so C&A was saying our acceptance is conditional, but also saying, but you accept our terms if you just take the carpets.
Exactly. The court saw that as CNA being perfectly willing to proceed with the transaction without getting explicit assurance of the buyer's assent to the arbitration clause. That undermined the whole expressly conditional argument.
So because the proviso wasn't triggered, what did that mean for contract formation?
It meant that CNA's acknowledgement did operate as an acceptance under 22071, forming a contract based on the original oral orders plus the terms in the acknowledgement.
Okay, so a contract was formed under 1. Now, what about the arbitration term itself? Where did that leave it?
That pushed the analysis into 22072. Since both CNA and the Carpet Mart were merchants, the arbitration clause was an additional term proposed for inclusion. The question then became, did it automatically become part of the contract?
And that depends on the exceptions in 2207.
Right.
Yeah, specifically material alteration.
Exactly. The final step in the analysis was whether the arbitration clause materially altered the oral agreements. The court noted that arbitration clauses are generally considered material alterations because they significantly change how disputes are resolved.
So the analysis ended on whether this specific arbitration clause was a material alteration.
Yes, that was the remaining factual question.
And the conclusion, what did the court ultimately decide?
The appellate court reversed the district court's initial dismissal. The lower court had gotten the analysis wrong, likely relying too much on the last shot idea or not properly applying 2207. The case was remanded, sent back down to the trial court. The trial court was instructed to determine, first, if the arbitration term was indeed additional to what was agreed orally, which seemed likely, and second, crucially, whether that additional term materially altered the contract.
And the implication being?
The implication was that if the arbitration clause was found to be additional and material, then it would not be part of the contract unless the Carpet Mart had expressly agreed to it, which they clearly haven't. So CNA was likely going to lose on enforcing arbitration.
That's a fantastic illustration of how 2207 works step by step. Okay, let's pull this all together. For someone facing a contracts exam or just trying to draft better forms, can you synthesize this into an actionable checklist for analyzing any battle of the forms problem?
Absolutely. This is your go-to diagnostic tool for 2207. 3 steps. Step 1. Is there a contract by writings under 2207? Look at the response document, like the acknowledgement. Is it a definite and seasonable expression of acceptance? Usually yes, unless it wildly deviates on core terms like price or quantity. If yes, immediately perform the proviso check. Is the acceptance expressly conditional on the offeror's assent to the new or different terms? Remember, Dorton, subject to is likely not enough. It needs clear language showing unwillingness to proceed without assent. If the proviso is triggered, no contract formed by the writings alone. Jump straight to step 3, contract by conduct. If the proviso is not triggered, a contract is formed under 2207. Proceed to step 2.
Okay, step 1 is all about formation and that critical proviso language. What's step 2?
Step 2. What happens to the additional terms under 2207-2? This only applies if you found a contract under step 1 and the proviso wasn't triggered. First, check. Are both parties merchants? Yes, and they usually are. The additional term automatically becomes part of the contract unless it falls into one of the 3 exceptions. A, the offer limited acceptance to its terms. B, notice of objection was given. Or most commonly, C, the term materially alters the contract.
And material alteration includes things like arbitration, significant warranty disclaimers, major liability limits.
Correct. Those big-ticket items usually get knocked out here unless expressly agreed upon. Now, what about different terms, terms that contradict something in the offer? Courts are split, but the majority apply the knockout rule here too, meaning both conflicting terms drop out.
Okay, so step 2 deals with the fate of new terms if a contract was formed by writing. What's the final step?
Step 3. Is there a contract by conduct under 22073? You only get here if the writings failed to form a contract in step 1, usually because the proviso was triggered or the response wasn't really an acceptance. Ask, did the parties act like they had a contract anyway? Did the seller ship? Did the buyer accept the goods and pay? If yes, a contract is formed based on their conduct. But remember the consequence. The terms are only those terms on which their writings agree, plus any standard UCC gap fillers, like implied warranties. All the conflicting terms and any additional terms that weren't agreed upon in both writings are knocked out.
The knockout rule again, so you end up with a very basic contract.
A very basic contract. It prevents one party from getting their way just because they sent the last form, but it also strips away potentially important custom terms if the writings didn't align properly.
That framework really clarifies the flow. Start with formation via writings, check the proviso, then look at additional terms and material alteration, and only fall back on conduct if the writings failed. It really hammers home the point from Dorton just how critical that specific, expressly conditional on assent language is if you really want your terms to control, and how risky it is to rely on sneaking important terms in through the fine print.
Absolutely. And that leads to the final thought for you listeners. Norton focused heavily on arbitration being a material alteration. But think about other clauses you might put in your standard terms. What about limitations on consequential damages? What about specific tight warranty periods? Or clauses requiring disputes to be litigated in a specific, maybe inconvenient state? Are those material alterations? Probably. So if you're drafting these forms, how do you ensure those crucial risk management terms actually stick? Relying on 22072 is risky. The safer route is often to get those critical terms explicitly agreed upon before performance starts, maybe in the master agreement, or by requiring a specific signature acknowledging those key terms, rather than just hoping they survive the battle of the forms.